minutes for people to trickle in before we get started down that are coming into the room. So let's get started. I'll start by saying our other panelist, David Fritchie, just sent me an email saying that he has been held up with a court hearing that he had this morning. So he will pop in as soon as he can. But we'll get started. And let me introduce our other panelist, Daniel. So Daniel Paz is the owner of the Paz Law Firm, a solo practice boutique firm focused on representing members of the multifamily industry. He has practiced law in the landlord-tenant industry for over 17 years. His practice focuses on residential landlord and tenant disputes and consumer bankruptcies. As part of his practice, he regularly appears before state, federal, and bankruptcy courts on behalf of property owners, landlords, and property management companies. He has extensive experience appearing before state courts on eviction appeals in the surrounding counties and appearing before bankruptcy courts on lift stay litigation in the Northern District of Texas and the Eastern District of Texas. He has handled all types of residential landlord-tenant litigation, including disputes over security deposits, repair and remedy, breach of lease, collections, and fair housing claims. He also handles disputes with vendors, including mechanics lien issues and vendor lawsuits. Mr. Paz obtained his law degree from the Southern Methodist University School of Law and holds a Bachelor of Arts degree in Political Science and Communications News Editorial from Southern Methodist University. He is admitted to practice law in the state of Texas and the U.S. District Court for the Northern District of Texas, the U.S. District Court for the Eastern District of Texas, and the U.S. District Court for the Western District of Texas, and the U.S. District Court for the Southern District of Texas, as well as the U.S. Court of Appeal for the 5th District. So thank you so much to Daniel for agreeing to participate in our webinar this morning. And Daniel, I'll let you say a few words if you have any, otherwise we can get started.
Yes, thank you, Armin. Welcome to this webinar. Hopefully we'll answer most of your questions today. Just has a housekeeping item. I am an attorney as well as David, but the opinions that we're giving today do not constitute legal advice. If you have a legal matter, you will be advised to contact your own attorney and discuss that matter and the particular fact pattern. The information here is mainly informational. It's not intended to be legal advice or to establish an attorney-client relationship between yourself and me or David once he's able to join the webinar. But I look forward to answering your questions, getting to as many as possible, and providing you with some information that you can use as we continue to attempt to evict individuals for non-payment during this era of the COVID pandemic. Thank you.
Thank you, Daniel. So I think we can start with the question that's maybe on everybody's mind, and I've seen a few questions on it already. The recent case that came out, Turkle v. CDC, in which the CDC order was deemed unconstitutional. So what are your thoughts on the outcome of that case?
Okay, and that case was entered out of a district court here in the Eastern District of Texas, which is up here in North Texas. I'm not involved personally with that case, so I'm just an observer, just like everyone else. And I've read the opinion, and the opinion clearly says that the federal government doesn't have the constitutional power to invoke the eviction moratorium as it did. So that's good. That establishes a basis for us to go into court and argue potentially that the eviction moratorium is no longer valid under the CDC. However, the way the legal authority ladder works, this is a federal opinion. It's at a district court level in the federal court system. As you guys may be aware, the federal government has recently decided to appeal that decision. So it's possible that when this gets to a court of appeals, it may be struck down or reversed, and then it will have no further legal effect as far as enforcement in the court system. Now, there's also a possibility that while the federal government has indicated they won't, that they may seek an injunction to seek application of it. But absent those two issues, as of now, that opinion gives landlords and landlords' attorneys, the ability to go into court and argue that the CDC eviction moratorium no longer applies, and we should be able to proceed with our evictions for non-payment. Now, again, that was one judge. There's many different judges out there that hear eviction cases, and they may have different opinions on it. They are definitely not bound by it. As that being a federal court opinion from the district court level, evictions are handled in the state court. So state courts are able to consider that what they call persuasive authority. It's not binding mandatory authority that they have to follow. So they can make their decision whether or not they agree with that opinion or not. And as a practical matter, I'd expect there's a lot of judges out there that handle evictions that may not view the opinion like that particular district judge did in Truckle, or they may simply say, well, it's on appeal. I'm going to wait to see what the appellate court decides on that issue, and I'm not going to deem it unconstitutional. So from a landlord's attorney, I like the opinion. I just don't know as a practical matter as it goes through the legal system, how much benefit that's going to give us as landlords when we're dealing in state courts and not in federal courts. Again, the eviction matters are within the exclusive jurisdiction of justice courts in Texas, and they will follow what has been set forth by the state. And right now, what they're telling us is that they'll continue to follow what has been mandated by the Texas Supreme Court. And until the Texas Supreme Court tells them that the CDC moratorium doesn't apply, they are going to likely continue to follow, the emergency orders that have been issued, throughout several past months that detail what the procedure is when it comes to dealing with a CDC moratorium declaration. So it's a good opinion on its face, but in practice, it may have very limited applicability until we get further answers from either the appellate courts in the federal system as to whether or not they're going to uphold that decision, and two, whether or not the Texas Supreme Court addresses the procedures for addressing CDC moratorium declarations in an emergency order of some sort. As of this morning, I checked the court's online website, and they've not issued any other order that would eliminate or remove the procedures related to CDC declaration challenges, which we may get to here as questions come along as to how that process works. But in Texas, it's my understanding that the justice courts, as well as the county courts, are going to continue to follow what has been promulgated by the Texas Supreme Court and not, adhere to the overall opinion of that district court action saying it was unconstitutional.
Thank you, Daniel. So just to recap what I've heard, the Texas Supreme Court is what is kind of in charge of the state court system. And the Supreme Court has not made any movement or indicated any movement toward taking down the emergency order. So as of yet, state courts are more likely than not to go ahead and follow the Supreme Court in not going ahead and taking down or not following the emergency orders.
That is correct. The justice courts, it's my understanding, through their training center, are being advised that until there is some sort of, mandate or emergency order that tells them to do otherwise, they are to follow the emergency orders that are in place, which provide for a mechanism to challenge CDC declarations, but overall have it apply. So that's how I believe in practice it's going to be followed until there's something from the Supreme Court, or again, the appellate court makes a decision that may be more binding or mandatory than what the district court action is at this time.
Thank you. So, I mean, this is an opinion, and I know that you don't have any way of knowing this for certain, but do you now expect more cases to be brought on a state court level, challenging it from inside Texas rather than the federal system?
I would expect some additional legal action. This definitely gives landlords, a basis to challenge this moratorium, as well as other eviction moratoriums out there that may exist. And so, yes, I would anticipate there may be additional legal actions brought at a state court level to, again, create some more binding authority. Again, that opinion that was recently issued is in the federal court system. And when it comes to legal authority, there's states courts opinions, state court precedent, and then there's federal court issues and precedent. And sometimes it's not always as binding what the federal court does. And that appears to be what is happening here with the Supreme Court, not yet making a decision or making an opinion as to whether or not they're going to adhere to that federal court decision, which again is currently on appeal. So there's still several questions to be answered, as well as the fact that currently, the CDC eviction moratorium, unless extended, is set to expire here at the end of this month. So it may be a moot point, but we'll see.
That's true. So as a practicing attorney, I see we have a question here about court proceedings being held in person or over Zoom. So can you give us any insight on your end on any eviction proceedings you've had, and if they've been in person or over Zoom?
Sure. Again, I practice in the North Texas area. So my practice area covers 4 counties mainly. It's Dallas, Collin, Denton, and Tarrant. And each county is different. There are some counties who will do in person. There are some counties who will do Zoom. And even within that county, there are different judges who have different opinion as to whether or not, hearings can be conducted via Zoom. Evictions are important matters. We're asking, people to be removed from their home and set out. And some judges still, it's very important that the defendants, have the ability to participate in that process on due process grounds, which is understandable and is the law. They're entitled to due process. And some may or may not have the technology or the financial ability to participate in hearings via Zoom. So what I've seen is, judges will prefer to do hearings via Zoom. They'll send out Zoom invitations and contact information, but they'll also send out with that, if you're not able to attend, call us, let us know, and we'll make the courtroom available to you. Okay. And then there's other judges who will just do it in person. I've had, during this time period, several eviction cases at the justice court level that are held in person, where all the parties appear and present their evidence and their cases, and the judge makes a decision. I've had several that are done via Zoom. So there's not no one set rule. There's not a governing process set by the Supreme Court that says this has to be followed. It's subject to the discretion of your local JP and your local courts. And so here in North Texas, I've seen, like I said, Zoom trials, and I've seen in-person trials. So when you file your evictions, hopefully the clerks are telling you what type of trial you're going to have, whether it's a Zoom trial or in person. And I've seen it here where precincts that have multiple places, one judge does his hearings via Zoom, and the judge right down the hall does it in person. So he can differentiate that easily amongst judges as to how they want to handle their docket. So again, when you file your evictions, it's crucial that you communicate and get information from the court clerks as to how they're going to handle the eviction. And if you want to have an in-person trial, you're not comfortable doing Zoom, by all means, ask the clerk if that's an option, because some courts do offer that as an option to the parties to participate in the eviction process because it's such an important issue.
Thank you. And so this kind of ties into our next question. I see a question from Carolyn, and I saw another question before. Carolyn says she's confused, Zoom or in person, are evictions being held at all? So this ties into the next question I had, which is what evictions can take place? If we're still assuming that the CDC order is going to continue until the Supreme Court steps in and does something with the emergency orders, what types of evictions can occur right now?
Sure. And I'll start off by telling you what the CDC moratorium protects against. Okay. It protects individuals who are a covered person, and a covered person being someone who submits a declaration and provides those certain declarations to the landlord and to the court. That protects that person from being evicted for non-payment. Okay. And non-payment would be non-payment of rent, late fees, utilities, things of that nature. Okay, so it's non-payment only that's protected if the CDC declaration is provided. Okay, that does not prevent you from filing other types of evictions. Okay, you can still proceed as normal with evictions, for what I consider prohibited conduct violations. Okay, meaning if your lease agreement prohibits your tenant from engaging in criminal conduct, and you discover that your tenants indeed engage in criminal conduct, you proceed with your eviction. Okay, you file it, you get your court date, you go to trial. So those are allowed to proceed, as well as holdover evictions are allowed to proceed. Holdover eviction being, you have a lease agreement, and a lot of people are in this situation because this lasted so long that it is expired and that you've given the proper advance notice of lease termination, and your tenant, for whatever reason, has elected not to move out. So then they become a holdover tenant. Those evictions are allowed to proceed as well. The CDC does not prevent those from proceeding. Okay. And here's a point that I want to clarify is that even if you get the CDC and you want to evict a tenant for non-payment, you can still file your eviction. Okay, there is nothing that prevents you from doing that. There is nothing that prevents you from giving the notice to vacate. What happens, and I can address it now, but I'm sure it'll be a question in the process, is that when you file your eviction, okay, and if it's for non-payment, okay, that's not a violation. That's been explained by the CDC that they were not intended to stop all evictions. What they intended to stop was the actual physical removal of residents from their property. So in Texas, what that means, and I've interpreted it, is the process of getting the writ of possession actually enforced. Okay, meaning if you're going to evict somebody, you get your trial filed, you get your judgment, you get to the writ stage, that's when you're stopped. Now, not all judges view it that way, and part of that is part of the Supreme Court process that I'm going to discuss here, is that when you file your eviction for non-payment, which again, you can, you have to notify the court that you file in as to whether or not you received a CDC declaration. Okay. Some courts have it in their petition. Some courts have it in a separate affidavit that you sign before notary, verifying that you received or have not received a CDC declaration. Okay. Additionally, the citation that's issued by the court is going to advise the tenant of their right to file a CDC declaration. Okay. So you filed your eviction, which you're allowed to. If you have a CDC declaration in hand, there's a couple of different ways to go about going through the eviction process. One is At the same time that you file your eviction, you can make a request to have a challenge, a contest of the CDC declaration. Or you can file it, after you file your eviction, after you get your cause number, a separate document asking the court to contest the CDC declaration. And what that establishes is that there'll be a hearing before your local JP as to whether or not the CDC declaration is valid. Okay. And the CDC declaration, again, is a document that's submitted by the tenant, in which they make certain declarations to you, the landlord, and to the court as to their current status. Okay, and you have the ability to challenge that. So that's the way the process would work when it comes to filing an eviction. The CDC declaration in of itself does not prevent you from filing the eviction. You can still file the eviction. It may pause, temporary halt, an eviction for non-payment, but you can still file. And by all means, it does not stop evictions for, again, prohibited conduct type violations of the lease agreement, holdover of lease agreements. Those are still, able to proceed, through the court system as we currently have the rules in place.
Thank you, Daniel. Good morning, David. Glad you're able to join us.
Good morning,
let me
everyone.
go ahead.
I apologize for being late. I was in Nueces County Zoom, so I apologize.
No problem. Let me go ahead and introduce you to our audience. David attended the University of Texas and has practiced real estate law since 1986. He has taught over 75 Red Book seminars for TAA and has successfully argued 2 landlord-tenant cases to the Texas Supreme Court. His representation of owners of real estate property throughout the state includes complex transactions and commercial and real estate litigation. His litigation experience covers problematic evictions to fair housing matters in federal court. And he has been appointed 4 times by the Texas Supreme Court to serve on task forces redrafting the rules of civil procedure. And he is currently serving on the Supreme Court task force drafting landlord-tenant forms for people who represent themselves in justice court. David resides in San Antonio with his wife Rochelle, daughter Elena, and son Nate. Thank you again for joining us, David.
Thank you. And it's good to see Daniel. Good to see you, Daniel.
I see, Dave.
So, David, we were just talking about what types of evictions can still take place. And Daniel answered that very well for us and dove into the process a little bit. And so let me ask this question to you. What if a property manager or landlord we've already answered that they can still file an eviction when they have received a declaration, but what if they are in the process of filing an eviction and then they receive the declaration?
Well, one of the pleading requirements under the current emergency order of the Texas Supreme Court requires you to put in your petition a specific allegation, a specific statement as to whether you have or have not seen or been handed a CDC declaration. So one of the allegations you have to make is, have you received a CDC declaration? Again, if you're in the process of filing, our practice has been to file a contest, if we're electing to contest the CDC declaration, to file a contest concurrently at the same time as we file the eviction petition. And that at least gets it in the pipeline for a hearing on the contest. One thing that you should always do is carefully review the CDC declaration to see if all boxes are checked. If they are not, then that's a basis to challenge or contest. And remember, all residents who are obligated under a lease have to file a CDC declaration. One CDC declaration for 3 residents. And again, the resident is going to be the named responsible party and or a person who actually signed the lease. there has to be a CDC declaration prepared and filed by each individual resident. So, there's nothing to prevent you from proceeding. There's been a lot of miscommunication or misunderstanding out there that all of a sudden the CDC declaration pauses an eviction. The interesting thing is there is a federal court procedure or proceeding in Atlanta where the CDC's order has also been challenged on constitutionality. And the interesting thing about that case is that the Department of Justice filed a response on behalf of the CDC that basically takes the position that the eviction that is prevented by the CDC order is the actual execution of the writ of possession. So there is this case in Atlanta where the CDC's lawyer have stated in a pleading that what is prevented by the CDC declaration is the actual writ of possession being served on the tenant and removing the tenant from possession. So I'm with Daniel. You just keep on filing, and one aspect of this that we've told our clients is when you file, you will at least be in the pipeline to be heard once the abatement period is over. And I think it's important to be in the pipeline because you don't want to be waiting to file until after the CDC order expires because you're going to be behind in the process. And the other thing is, in the meantime, you may be able to participate in the Texas Eviction Diversion Program and the Texas Emergency Rental Assistance Program.
That's great, David. We just got a follow-up question from Troy stating that what happens if the tenant can the tenant make a declaration at the hearing itself? So they haven't given one up to the point where the hearing is happening.
They can submit the declaration before, during, or after the hearing. We've had situations, and I'm sure Daniel's seen this too, where there has been a final or a judgment issued, the defendant appeals with, for instance, an affidavit of inability to pay costs. They fail to pay in the registry. We request a writ for failure to put the 1 month into the JP Court registry. Then they file the CDC declaration and the case gets paused, gets stopped. Mm-hmm. Unfortunately, in that circumstance, the Justice Court Training Center has advised the JPs that their interpretation of the Supreme Court emergency order with regard to abatement stops even sending the file to the county court for appeal. So, a pause is going to occur, but if the CDC declaration is given to you before, during, or after, until a contest is filed and that contest is sustained.
Great, thank you.
And if I may, if I can add to that real quick,
please
to answer that, is that, under the rules, the Justice Court, your JP, has an obligation to develop the case, and they will ask your resident, whether or not they have delivered a CDC declaration, and perhaps explain to them what that CDC declaration is and what protections it may offer. So there is a possibility, as David indicated, that you may get it at the trial, you may get it after the trial. I've had situations where, similar to what David was speaking of, we go through the JP Court trial, we get our judgment, it gets appealed to a county court, and at the county court level, they get counsel, and then the CDC declaration is filed. So up until the time that you get possession of the property, they can give you that CDC declaration, and you'll have to address it. I like to advise my clients, it's similar to getting notice of a bankruptcy. Until you get possession of the property, no matter what stage in the process you are, if you get it prior to gaining possession of your property, you've got to address it. You've got to stop. So there's not a quote deadline for the tenant to give it to you before the trial, after the trial. The only deadline would be prior to you gaining possession of the property. And because there's so much information and opportunity, you're going to see that they're going to give it to you at some point during the process.
I want to point out another, as a follow-up, another reason to challenge. Remember, the CDC declaration is solely intended to address a non-payment of rent issue. We're not talking about holdover. Holdover should not be subject to a CDC declaration where you've given the proper advance notice of termination at the end of the lease term, or a for cause eviction. If you have a non-monetary default, the CDC declaration, you might have one filed or provided to you, but a contest on the basis that it's not applicable to that type of eviction should be filed.
And unfortunately, unfortunately, there's some confusion that's created because the way the Supreme Court emergency orders are written is they don't determine, whether or not the eviction would be covered by the CDC moratorium. Is that when they send out their citations, they will put out there the ability to put a CDC declaration, which, a tenant will see, and they will file one, and you'll have to explain to your JP court judge, that's good, they filed a CDC declaration, but it doesn't provide them any protection in this eviction because we're not here about a non-payment issue. We're here because of a holdover situation. We're here for prohibited conduct, for cause type violations. And so that does create some confusion just by the way the courts, the Supreme Court of Texas has ordered citations to be issued in eviction cases.
Along those lines, Daniel, finding that there is confusion with the courts themselves in understanding exactly what's going on here?
Yes. JP judges, there's no requirement that they be an attorney. So a lot of times we have JP judges who are not attorneys who are asked to make legal decisions and interpret provisions and rules and statutes. And so some judges, will automatically, halt your eviction case when a CDC declaration is filed, whether it's for a holdover or for prohibited conduct or for cause. They require you to file that contest to get that issue brought before them. There's other JPs out there who will look at the pleading and determine this doesn't apply, and they won't require you to file a contest. So again, it's very specific to your judge. Just like we talked about whether or not they're going to hold Zoom trials or in-person trials, the way the judges handle their dockets and they move these eviction cases along, is very, 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 specific to your judge. So it's crucial to know who your judges are and how they practice. And if you have the ability, I know here in Dallas County, we have the ability to have different judges in different precincts. If there's one judge who's addressing the process differently, that may be more favorable to what you're trying to accomplish, by all means, file in that place, that precinct in place, because it's going to be beneficial to you. So yes, as with everything, there's different opinions, and that causes confusion because JP judges do things differently. They control their dockets differently. And sometimes, it's not based on legal, reasoning. It's just their personal practice, their personal opinions.
So Daniel, are you suggesting forum shopping?
I'm not suggesting forum shopping in the sense that you're going from precinct to precinct, but I'm suggesting that if there's an opportunity to choose your judge, by all means, take advantage of that.
Well, and a good example, Daniel, is in Harris County. I think there are some precincts that have actually three places, three different judges, place one, place two, in place 3. And that's what Daniel is talking about. Know your judge and be able to file in your precinct and a particular place. If you've got judges, for instance, that expedite eviction cases, you want to be where that judge is going to hear the case on a very timely basis.
Along those lines, so, you know, judges are doing things differently from court to court. If a tenant fails to show up at an eviction hearing, in your experience, has that resulted in a default judgment with the writ of possession, or, you know, are judges being extremely lenient during this pandemic and kind of giving tenants another chance to show up or something?
Again, that's very specific to your judge. There are some judges out there, if they don't show up, you get a default and all you have to do is stand up. You don't necessarily need to present any evidence or information to the court. There are other courts out there, if they don't show up, that require you to go through the process, you know, establish the landlord-tenant relationship, you know, provide proof that you gave a notice to vacate. There are other judges, particular, who feel that if the tenant has filed a CDC declaration and does not show up, then you're not going to be entitled to a default judgment. That there will be a reset, an opportunity for the tenant to appear to address that. And similar to that, even if you file a contest to a CDC declaration and the hearing is set on that CDC declaration, I've seen JP judges that even if the tenant doesn't show up, will give them another opportunity to appear because, you know, they're just, you know, managing their docket as they feel fit. So again, it's specific to your judges and how they handle it. But yeah, it's kind of a mixed bag. You know, yes, some will give you a default judgment, like I said, simply standing up and saying, yes, I'm here as the landlord, give me judgment, and they will. And there's others that require you to go through the process. And then there's others who will give the tenant, you know, an opportunity to appear at a later date, from my experience. David, have you had similar experiences?
You know, the same issues happen where we practice, Daniel. You may get a 1-week reset where if the tenant doesn't show up, the court may direct the clerk to re-notice the tenant for a hearing on the CDC declaration. There are any number of permutations that can happen, and we have found that, you know, from week to week, certain judges have a different style of handling their docket. Some have become very impatient. I think they're starting to feel the brunt of and the weight of the number of evictions that are out there. And some have, I think some have serious concerns about violating the CDC order, notwithstanding that federal court in East Texas declaring the CDC order unconstitutional. So it's a mixed bag all the time. And that's why what Daniel and I do and what you all do is called practice. I mean, it's real estate management practice. It's the law practice. It's never perfect. And you learn something every time that you appear in court. And I know you guys as property managers juggle a lot of balls in the air and deal with the crisis every day. But we're practicing.
I'm seeing a lot of questions in the chat or in the question queue still about holdovers or for-cause evictions. So I have a question. Do we still have to follow the 30-day notice to vacate, or would they just go by what their lease, the notice required by their lease at this point?
Are we talking about in the holdover eviction sense?
Yes. Okay.
And this is a point I want to make, is that when it comes to holdover eviction, it's a two-step process. Okay. You know, sometimes there's some confusion as that I can just give a notice to vacate once the lease is set to expire and I get possession. No. So I want to kind of clarify the question as to when they say 30-day notice. Okay. The first step in a holdover eviction is that you've got to terminate the lease. Okay. And that will be governed by your lease document. your lease document will tell you you need to provide 30 days advance notice of lease termination. You need to provide 60 days notice of advance lease termination. Okay, so that's step number one. You got to comply with the terms of your lease as when it comes to providing notice of the lease being terminated. So that can be 30, it can be 60, whatever your lease document says. Okay, and if it's absent and it doesn't have any lease termination, and you're renting on a month-to-month basis, then you can provide a month's notice, 30 days notice of lease termination. Okay, so that is still required regardless of the CARES Act, regardless of the CDC eviction moratorium. That is state law. Okay, so that's step number one. Okay, step number two is your tenant doesn't vacate at the end of the lease term. Saying you gave them 30 days notice saying your lease is expiring on March 31st, 2021. They're still in the property on April 1st, 2021. At that point, they are now a holdover tenant, and you have to give them a notice to vacate. Okay, and the notice to vacate by law would be 3 days or perhaps 1 day based on your lease agreement. Okay, however, this is an open question, and David may have a different opinion on it, and judges may have different opinions on it. Okay, is that under the CARES Act, okay, which that eviction moratorium expired last July, there was a requirement that if you were a covered property, meaning you had a federally backed loan on your property, or that you participated in some sort of federal housing assistance program, that you had to give a 30-day notice to vacate. Okay. Unfortunately, because the CARES Act was, a very small part of an overall stimulus package, they didn't answer or address all the questions that it created. And one of the questions it created was whether or not you had to give 30 days notice after July, after it expired last year. And so, the safe bet is yes, give them a 30-day notice. The aggressive bet, is to give them the 3-day notice. But again, as David and I have mentioned, know your judges. Okay, some judges will tell you, no, I look at the CARES Act, and I believe that if you are a covered property, that you need to give 30 days notice, even today, for a holdover eviction, even though, again, holdover evictions are not protected under the CARES Act. Other judges will say, no, it's not under the CARES Act non-payment eviction moratorium that existed, so you should be able to proceed under state law. So the question being, are 30 days notice is still required? I guess the best answer is it's possible. Know who your judge is. So David, what's your thoughts on that question?
Well, unfortunately, there was no sunsetting to the CARES Act. And there are frankly 3 interpretations on notices to vacate under the CARES Act. You will find that legal aid takes a very aggressive position in certain cases, because there's one interpretation that you can make, that all notices to vacate, even for prohibited conduct, would require a 30-day notice under the CARES Act. And again, that's why Daniel says, know your judges. The most, I wouldn't say most aggressive, but a prevailing position has been, so long as you're not giving a notice to vacate for April, May, June, or July rent, the rent that was in the moratorium period, you can go back to a 3-day notice to vacate, even in a CARES Act property. But that's an aggressive position. And again, if you don't know your judge, you need to talk to one of your colleagues who's been in front of that judge, or talk to the local board council to see if you can find out how particular JPs are handling their docket on notices to vacate. And frankly, there could be 3 different interpretations. And it's judge to judge sometimes. I will tell you from our perspective, CARES Act or not, we're doing the two-step process that Daniel provided, either the 30 or 60-day notice at the end of the lease term, and then a 3-day notice to vacate for the holdover when they don't vacate at the end of the lease term. Because basically what you're doing is you're terminating the lease term as opposed to terminating the lease. And you want to be real careful that your notices to vacate and your notices of termination don't ever terminate the lease, because if you allow a tenant to take the position that the lease is terminated, they have no further duty under the lease. So be very careful. I want everybody to understand you have the lease contract, which has the duties and responsibilities of the landlord and the tenant. And then you have the lease term, January 1 to December 31st. What you're doing with a notice of termination at end of lease term is you're saying, basically, we are not going to renew your term, and we are terminating your lease term on December 31 at the end of your lease term. And as Daniel says, if they don't move, they become a holdover tenant, and there are going to be provisions of your lease that deal with what holdover rent is, for example. So added holdover after termination at end of lease term, you want to give a 3-day notice unless you know you have a judge that follows the CARES Act 30-day requirement.
I do have a question here about the burden of proof when contesting CDC declarations. So is that on the tenant or the landlord to prove that something might not be true?
That's another great question that goes judge to judge. I have one judge here in San Antonio in Bexar County that almost has the burden of proof that I have to prove for the landlord beyond a reasonable doubt that the tenant is lying on the declaration. Well, I think in just about every case under a CDC declaration, there is a reasonable basis to contest, because the elements required to obtain the protections of a CDC declaration as set forth in that declaration that is purportedly under the penalty of perjury, they're very difficult for a tenant to really and truly comply with and to establish. So again, depending on your judge, the burden of proof is a difficult call, and again, it's going to be I think, court to court situation, because we know that we have, for instance, one judge here in San Antonio that, unless you have specific proof that the tenant has lied about one of the components of the CDC declaration, he's not going to hear it. He's going to abate it and deny the contest. So again, as we go through this process, I think one of the big points that you're hearing, and unfortunately, Daniel and I can't give you a precise answer, because part of the discretion that was given to the courts, the JP courts, by the Supreme Court in the Supreme Court emergency orders, is how they handle their docket. And because of COVID-19, and a lot of JPs have taken that instruction from the Supreme Court and used it probably beyond the Supreme Court's intention. So again, I wish I could give you a specific answer. Daniel may be able to be more specific on the burden of proof, but I see it as a judge to judge determination.
And I had similar experiences, David. Practicing up here in North Texas, like I mentioned at the beginning, I have 4 different counties that I practice in primarily. And the way they approach them varies by county, and it varies by judge. There are judges, that if you file your contest and you walk into the contest hearing, the first thing they do is they look at the tenant and they start asking them questions about the declaration and asking them to provide evidence for that. There are other judges, when you walk into that hearing, will look at you as the landlord and say, prove to me that this declaration is not accurate. that they have somehow provided information that's not accurate. And that's extremely difficult when you have the situations where the tenant doesn't show up to the declaration hearing, okay? And the judge places the burden on you, the landlord, to prove that that's not accurate. And for your example, there's a required declaration that they use their best efforts to obtain, government housing assistance or housing available funds. And from a landlord's perspective, you can stand there and testify that I've not received any, inquiries from any organizations or governmental organizations asking for assistance. I've not received any applications. I have not received any, no fund request or proof of lease agreement, things of that nature that are typically associated with gaining housing assistance or government assistance. And you tell that to the judge, and the judge says, well, how do you know they didn't apply? Just because you didn't get it doesn't mean they didn't apply. And so they're placing the burden on you, which is almost an impossible burden in that situation, to prove that the tenant didn't do something when the tenant's not there. And so again, as David mentioned, it's judge by judge, that they view who the burden is on to prove it. And so you've got to, again, sounds like a repeated record, you've got to know your judges. You got to know what information you need to prove. So as David mentioned initially in his opening comments, at the very beginning, you need to make a decision as to whether or not you're going to contest this CDC declaration. And part of that analysis is what judge you're going to be in front of, and do you have the information to meet their requirements, what they're looking for to successfully challenge a contest. So that's just one of the issues that goes into your analysis of whether or not you're going to contest a CDC declaration.
Wow. So much uncertainty out there.
Unfortunately, yes.
So let's talk a little bit about the I know you mentioned this a little bit earlier, David, the Texas Eviction Diversion Program. Have either of you had any experience with an eviction leading to that program? And if so, would you mind telling us a little bit about that?
Well, sure. There, at least for San Antonio now and some of the other jurisdictions around the state, landlords and tenants now have access to 3 pots of money. There's the original $130 million from back in September that was established into the Eviction Diversion Program, the EDP. The Eviction Diversion Program only kicks in after an eviction is filed, and the tenant can apply for eviction diversion funds only after they have been sued in JP court for an eviction. Until a month and a half ago, I was advising clients, do not consider going into the Eviction Diversion Program, because the TDHCA form that the landlord had to sign basically used to say that the landlord waives all financial liability of the tenant, not the rental liability. That form has been revised significantly by TDHCA, and so long as you are using one of the revisions in the Eviction Diversion Program of the landlord certification from TDHCA that was revised after the first of the year, the inappropriate language has been removed, because you are then waiving only rent liability. Now that's the Eviction Diversion Program. On February 15th, TDHCA rolled out TREP, the Texas Eviction Rental Assistance Program. That program was funded with $1.3 billion from federal money. And again, TREP uses a similar certification form, and it has been revised to remove offending language that could waive rights of the landlord. And then Your local jurisdiction, for instance, here in San Antonio, the city itself has an emergency housing assistance program, which also uses a similar certification form. The key issue with using these rental diversion programs, either in the eviction court, which is a program that's set up by the Supreme Court and the Office of Court Administration, or the separate TDHCA or local rental funding, funding programs, you need to be careful and read carefully what you have to say in your certifications to obtain that rental assistance. The good thing is, since September, all of these rental assistance programs have been cleaned up substantially to remove what used to be language that we as attorneys couldn't recommend our clients enter into. And I'll kick it to Daniel on his thoughts on those programs.
Yeah, my experience isn't from a practical matter. Being up here in North Texas, these programs have only recently become available to our counties. So I've not had any practical case, application of these processes. It's all just based on what the programs are and what they provide. And the one thing I want to highlight to you and emphasize is that, these programs are voluntary programs. Okay, it's not a mandatory participation program. So while the judge may ask you about these programs, you can't be forced to participate in it, which is why David's advising that you read your documents that they're asking you to sign, because you may be giving up a right that you don't want to give up. So I don't have anything to add to David's excellent answer as to that process.
Let me follow up one thing with regard to the eviction diversion program. Again, the eviction diversion program is after an eviction is filed. There is a major caveat with regard to that program. What happens if the parties tell the judge that they want to explore and participate in the eviction diversion program? The judge abates the case for 60 days. The case is paused for 60 days to give the parties the opportunity to file the appropriate paperwork for the funding. The danger that you have to be concerned about on the eviction diversion program in JP court is that if you haven't received the funding within that 60-day period, you must file in the JP court a motion to retain. In other words, a motion for the judge to keep the case. If that motion is not filed within 60 days, at the end of the 60-day period, the case is dismissed with prejudice. And that is very dangerous to have a dismissal with prejudice. You would need to appeal it immediately, because a with prejudice dismissal means that if you ask for rent, if you ask the judge to award you the back rent in your eviction case, the moment the case is dismissed with prejudice, you have waived every penny of rent that had accrued up to the date of dismissal. So that's an additional 2 months during even the eviction diversion program. So you have to be very careful that you calendar within 60 days your filing of a motion to retain if you decide to participate in the eviction diversion program.
And David, I think it's true that you also risk, for example, if you have other claims attached to that eviction suit, you risk losing all the claims you're making.
Absolutely. In other words,
so along those,
prohibited contact, unauthorized animal, or the like. Absolutely.
So that begs the question, I just saw someone with the question that they have a pet violation in addition to a delinquent rent issue. So if they were to file both of those issues in an eviction suit, or both of those claims, what would happen? Would the abatement kind of, or the CDC moratorium kind of hold off on everything, or what would happen?
Well, my experience in addressing those issues is that if you have a for cause eviction basis, such as the unauthorized animal, is that yes, while you would like to get a judgment for rent, that to clear up the process and avoid any complications with your judge is to simply move forward on the unauthorized animal. Because you can always go back later after you get possession of your property and file a suit for the rent. Okay, you're not required to file a suit for unpaid rent as part of your eviction. Okay, you can always do that at a later date. So my way I advise my clients is that if we have the ability and we have the evidence and we have the information to establish another for cause violation, such as the unauthorized animal, that we proceed with that and list that as the sole basis. Otherwise, it could get complicated and you could get into arguments regarding whether or not, it's just a pretext that you're trying to get them evicted for having an unauthorized animal. And this is truly about non-payment of rent. And you're just attempting to run, an end around the protections of the CDC eviction moratorium. So from a simplicity point of view, if I were in that situation, I would strongly consider, proceeding with the eviction just based on the unauthorized animal violation. But that doesn't mean you can't add both claims and proceed with both bases. Just understand that there may be some additional questions or perhaps some complications, because if they do file that CDC declaration, you may have to file a challenge to it because you now have a non-rent allegation in there. So that would be my approach to it. David, how do you feel about that?
Well, I agree with Daniel on the analysis. The one thing I would say is if you use counsel to file your evictions, you should talk to counsel about potentially, using 1, 2, or 3 violations within the same eviction petition. But that has to be done very carefully, because if you're using counsel, technically the counsel may be able to non-suit a portion of the case before it is heard if you learn that there are issues with that particular judge. That's a very technical aspect of procedure, and I would only consider that if you're using counsel.
And so I've seen this question pop up a couple times. We talked about, the true intent of the CDC eviction order or ban being that a writ of possession is not issued. So if you do go through the process, do you then get a judgment with no writ? Is that how that works? So that when the moratorium expires, it's just a quick process to get that writ?
Well, again, it depends on your judges. Okay. From a legal perspective, the way I would approach it is that you should be able to get your judgment. You should be able to get a judgment and not be able to request a writ. The question that arises is that under the Supreme Court, the rules for evictions is that a writ can only be issued within 60 days of a judgment being issued. Okay. And right now we're with a scheduled expiration on March 31st, you'd be well within your 60 days to request a writ. The initial analysis was, well, what good does it do me to get a judgment if I can't get my writ, for 120 days, 150 days? And the rules as written, again, subject to the COVID emergency rules, which allowed some courts of discretion, was that you could only get an extension on the writ for 90 days from the date of the judgment. So it was a question of whether or not it was even enforceable to get a judgment if you couldn't get your writ, because of the CDC declaration. But you're going to see is that if the court deems the CDC applicable, they're going to stop you. They're not going to let you go all the way to the judgment. They're going to stop the eviction case, whatever process they're at, whether it be you just filing the case, trial being set, they're going to stop it. But based on the intent from the CDC and their attorneys, it's arguable that I would argue that you should be able to get your judgment. The courts should have always been able to allow you to get your judgments. Unfortunately, that didn't happen, and I don't see it happening going forward. So as a practical matter, you're going to be halted. But from a legal perspective, the argument could be made that, yes, you should have been able to get your judgments and just have them on hold until the CDC declaration was either successfully challenged or the moratorium ended. David?
I've got nothing to add. I think Daniel's spot on.
Great. So we're starting to wind down the webinar, and before we do so, I wanted to ask both of you specifically what you think we haven't talked about, or what issues you think we haven't discussed yet that you think are very important to this discussion, or words of advice you want to leave our audience with.
You go first, David.
Well, a couple of things. Look at and have as a resource the Texas Justice Court Training Center website. The Texas Justice Court Training Center is pushing out advice to judges that all of us can follow. So if you Google Texas Justice Court Training Center, they have basically a COVID-19 page that has a series of resources that the justices of the peace rely on for their day-to-day practice, because that is the Justice Court Training Center is where the JPs go for continuing education. That web page can kind of keep you up to date with what you should expect from a particular JP. And if a particular JP is not following that advice, it also provides you a resource to say, well, Judge, the Justice Court Training Center mentioned XYZ, and you may be able to use that in argument. I do know that the Texas Justice Court Training Center and the Texas Apartment Association have asked the Supreme Court to clarify their orders, their emergency orders, since the CDC order was declared unconstitutional by the federal judge in the Eastern District. The other thing that I would say is, don't be afraid to try your case, because remember, both parties have the right to appeal out of JP court. And if there is a mistake made or the judge rules against you when all of the evidence was in your favor, you've got an absolute right to appeal to county court for a new trial. It's basically a do-over. And the last thing that I just want to mention, and Daniel may have mentioned this before I got on, you have to be careful about the local jurisdiction where you practice. For instance, the city of Austin has an ordinance that requires a 60-day notice and right to cure before you can give a notice to vacate for non-payment of rent. In the city of San Antonio, there is a form that must be provided to the tenant within one business day of giving them a notice to vacate for non-payment of rent, and that is the notice of tenant's rights. The point is, you may have local, and I know Kyle does, San Marcos does, Daniel's got a bunch of jurisdictions up there that he has to deal with, where the cities have added to your burden regarding notices to vacate and filing evictions, which in my opinion is unconstitutional. because I don't think cities typically have jurisdiction to change the statutes against you, particularly since the governor never authorized cities to exercise emergency power under a provision of the government code. So with regard to this third point, know your local jurisdiction's extra rules so that you don't have to start over on appeal.
And kind of building on David's comments there, when we're talking about local jurisdictions, we're talking about cities and we're talking about on counties. Like I mentioned, I practice in North Texas. The city of Dallas, has their own requirements as to how much notice has to be provided. They call it a notice of intent to evict that has to be provided, as well as in the past and potentially currently, Dallas County has issued their own kind of eviction moratoriums amongst the JPs that set forth certain moratorium deadlines. So while we focused here today on talking about, the CDC eviction moratorium and touched on the CARES Act and talked about the emergency rules from the Texas Supreme Court, there's another layer that David mentioned, which is the local requirements, whether that be a county requirement or a city requirement. You guys need to be aware of that. The other thing that I want to emphasize is that you are not helpless in this process. Okay, you are not subject to not having any ability to gain possession of your property. You do. Okay, you have the right to file your eviction still, even for non-payment of rent. If you file your eviction for non-payment of rent and you get a CDC declaration, you have the right to contest that CDC declaration. You're not held up. And if you're successful in contesting that declaration, you're entitled to move forward with your judgment and get a writ of possession. Okay. And I'm not sure we covered this, but briefly go back to it, is that when you file a CDC contest, you will have a CDC contest hearing first, and then you'll have a trial. So while in the past we're used to just going and having an eviction trial, in the CDC context that we are in now, there's two proceedings. Now, sometimes some courts will do this on the same day. Some will say, okay, you won your contest, now I'm going to reset your trial, and they'll set it for a later date. So expect that there'd be two separate matters. And when you go to court, understand what you're going to court for. Okay. If you file a contest and you get a hearing set, understand you're going there for a CD contest hearing, not the eviction. So you need to be prepared with whatever evidence and information you have to dispute the validity. Don't walk into a CD contest hearing and just have your lease, your notice to vacate, and your ledger, thinking that's all you're going to need to successfully defeat a contest, because that's what it takes to defeat an eviction or to prevail on an eviction. Understand that it's a two-step process. There's two different pieces of information that you need to provide the court when you contest a CDC. So again, know your local ordinances, understand you have rights and you have the ability to gain possession of the property. You just got to take these additional steps that we've gone over today.
Thank you both. And David, we had Daniel kind of talk to us a little bit about the case you were mentioning out of the Eastern District, and we'd love to hear your thoughts on it. And maybe you can also add, you guys mentioned local orders, but do you see anything changing with the governor's decision yesterday to kind of open everything back up? So do you think that local ordinances might now have greater issue with that on the horizon? We'd love to hear your thoughts.
And that's a good question, Iman. So the Department of Justice immediately filed an appeal of the order that was issued by the Eastern District of Texas declaring the CDC order unconstitutional. The interesting thing about the order is that there was no temporary injunction against the CDC issued. However, the judge invited the plaintiffs to come back to him if they were having problems because the CDC was not following that order. Now, many times in that type of case, the judge will issue the order and perhaps issue the injunction, but stay his or her order pending the appeal. That did not happen, but there is also no injunction. There's no injunction that issued. So you want to watch what happens with the CDC going forward, because I see two issues. I think there's a very strong likelihood that the CDC order will be extended. I think the Biden administration, the last I heard, wants to extend it maybe to September, possibly. But this order that issued in the Eastern District of Texas has to be appealed to the Fifth Circuit. The Fifth Circuit is notoriously conservative, which may mean there is a likelihood that the order may be sustained in the Fifth Circuit, and then it would have to go to the U.S. Supreme Court thereafter. The interesting thing about the Department of Justice's appeal was they tried to take the position that, well, this judge issued this ruling on the unconstitutionality of the CDC order, but it only applies to the plaintiffs in that case. The property owners up in East Texas, the 4 or 5 plaintiffs that filed the case, Ms. Turkle and the rest, I don't believe the DOJ is correct. If that judge declared the CDC order unconstitutional, I don't see how it could only be unconstitutional for one owner and not for everybody in Texas who's an owner, and anybody in the country who is an owner. So stay tuned to that, and we'll see if that judge goes ahead and issues an injunction on this notice of appeal while the appeal is pending, and we'll see what the Fifth Circuit does. Oh, and Iman, I really don't think that what Governor Abbott said about, opening up Texas is going to affect the federal judge's opinion. It may affect the Supreme Court. And as we've talked about this, and I've checked while we're talking, the Supreme Court has issued 35 emergency orders in succession since March, dealing with evictions and other proceedings in courts around the state. Most of the emergency orders, or a lot of them, dealt with evictions. So everyone needs to have on their radar screen, watching for this 36th emergency order. And I'm sure, Iman, you guys will push that out once you're aware that it may have issued, push it out to the membership of Texas Realtors so that everyone can stay informed about what the Supreme Court is telling JPs to do. I think that is the key. What is our Texas Supreme Court going to say?
So a little bit of a spin on that was, do you think that the local governments, local ordinances that we're seeing in Austin and in San Antonio, that they're going to lose ground or have less authority if the governor states that everything is opened up? Does that give people more room to challenge those local ordinances?
I'm not sure Open Texas Up gives them more room, because Austin, everybody realizes, is an unusual jurisdiction in the entire state of Texas. I think very likely what the city of Austin's ordinances that have issued are probably not authorized. But until somebody challenges it, bites the bullet, and challenges those ordinances that have passed, I don't think anything's going to happen. And particularly in Austin, Councilman Kassar and Mayor Adler have seemed to be very tenant proponent during this entire process. And it's Councilman Kassar who has pushed the tenant protections. I don't think the governor is going to influence the city council in Austin or the county judge in Austin.
Daniel, did you want to jump in or?
Well, my thoughts on that is that based on what Governor Abbott decided and announced yesterday, that at least in particular jurisdictions, Austin, perhaps Dallas County, there may be additional efforts by the local governments to impose some sort of protections for tenants. As of this morning, I had a hearing in front of a county court law judge, and she announced that as of right now and for all foreseeable future, Dallas County is still requiring people to wear masks. So I see that there will be certain jurisdictions out there who will, establish their own requirements, perhaps additional protections for tenants in light of what Governor Abbott decided yesterday to announce about opening up Texas.
Okay, and I think we have room for one more question, and I see Jim with kind of a cheeky get around of the CDC order. He's asking, can we sue an existing tenant for money owed rather than the eviction aspect under current rules? So you're suing for the money owed, you're not suing for an eviction per se. What are your thoughts?
Yes, I believe you can file a suit, separate and apart, and it's just a money judgment. And that's, exactly what you get, a money judgment. You would not be getting an order that says you're entitled to possession of your property. So if you are satisfied with getting a money judgment that is basically a piece of paper that says, yes, they owe you the rent, yes, I don't see that being prohibited by the CDC. The CDC prohibition goes to, again, possession of the property and eviction. And a suit for rent is a small claim suit. It's a suit on a debt, breach of contract. It's not an eviction. So yes, you can, but you're not going to get a judgment for possession in that situation. You're just going to get a judgment for money owed.
And if I could follow that up, Amon, that reminds me of two issues. Number one, the jurisdictional limit in justice court went up from $10,000 to $20,000 last September. So you no longer have that $10,000 cap on what you can go in to JP court for, and that's important. The other little twist to it is maybe you represent an owner that has a significant rental unit that has maybe $3,000-4,000 a month in rent. The law basically says that as long as your amount is below $20,000 when you file the suit on the rent, it can accrue beyond the $20,000 limit as long as it does so during your case pending. So potentially you could get a $24,000 judgment within the jurisdiction of the JP court because of this little twist in the law that says, as long as you filed under 20K and it was truly under 20K at the time you filed, that amount can go up.
Great. Well, I think we've come to the end of our webinar.
Iman, one thing I want to share real quick. One of your attendees gave the Justice Court Training Center website. Let me find it when it came through. I just saw it in the Q&A. I'm not sure what happened to it.
Might have been.
I think it was Jim who pushed out the Texas Justice Court Training Center website, and maybe it's in the answered section. Everybody should find that if we can. There it is. Yeah. It's in the answered section from Jim Smith, the Justice Court Training Center.org, TJ ctc.org//coronavirus. Jim, thanks for pushing that out there for us.
Thank you, Jim. So yeah, I wanted to thank Daniel and David so much for being with us this morning and answering all the questions we've had. Panelists, we thank you for your time and your fabulous answers and direction that our property managers are so happy to receive. Should I direct any emails to you from our audience inquiring about maybe working with you all?
Yes, I'm sure both of us
Absolutely.
be happy to. And with Zoom hearings, you know, Daniel can appear in the Valley and I can appear in Amarillo. So, I mean, the way things are going with Zoom hearings, we're happy to help. I know Daniel's happy to help. It's just a crazy time, just a
Yes.
crazy time.
Yeah, absolutely.
Yes, it is. So go
I
ahead,
enjoyed
Daniel.
doing this today.
It was
Thank
fun.
you.
It's always fun. Daniel,
Good.
good
I'm
to
so
see
glad.
you too.
I'll see you, Dave. Yes.
All right, so everybody, if you do need to contact either David or Daniel, please reach out to me and I will forward you to them. Thank you for your time.
Thank you, everyone.
David,
Everybody stay non-viral.
that's right. All
Yes.
right, everyone, have a good rest of the week. Thank you for your
Right.
time today.
Thank
Thanks
you,
for
guys.
having us.